Matter concerning the state grand jury. May we please have appearances of counsel?
Good morning, Your Honors. Michael Zuckerman from the Office of the Attorney General on behalf of the state.
Our Sandy from Lawrence Alexander on behalf of the official committee of court claiming credit.
Good morning, counsel, and welcome. Mr. Zuckerman.
Good morning again, Your Honors. If I could just reserve a few minutes for rebuttal.
That's fine.
Thank you, and may it please the court. Decades of child sexual abuse by trusted clerical leaders and the conditions that allowed that abuse to go unchecked for so long continue to cause profound harm to individuals and families across our state. The trial court's decision blocking the state from even pursuing a presentment on that topic should be reversed. Initially, this case arrives in an unusual posture. Standing alone among the New Jersey dioceses, the Diocese of Camden obtained an order below that no presentment on this topic could ever be valid. The diocese claimed a right to this pre-presentment review based largely on its theory that grand juries may never issue presentments unless the harms they address arise from strictly governmental misdeeds. But that core argument cannot be squared with the relevant court rule, with precedent, or with first principles. To start, under this court's rule, the presentment power extends to any public affairs or conditions and not just to any topic involving governmental affairs or conditions. And as numerous amici have emphasized, this topic is in no way one of mere private or esoteric concern. Precedent confirms the state's reading. Camden 2 makes clear that the grand jury is permitted to speak on any topic affecting the morals, health, sanitation, or general welfare of the community. And systemic wrongdoing can equally jeopardize those interests, regardless of whether it arises from governmental or non-governmental sources. The Monmouth County case underscores the point, reinstating a presentment about obscene literature. So too with other past presentments, from those addressing domestic violence, slaughterhouses, and a factory fire, to the 1996 presentment about a pipeline explosion. In short, there is no basis for the bright line government-only rule the Diocese of Camden presses. As for the various subsidiary arguments the diocese adds, those arguments are likewise misguided, but in any event, they are hopelessly premature. Indeed, those objections rest on at least 4 wholly speculative assumptions, none of which would preclude this process from going forward. First, the diocese assumes that a grand jury will vote to issue a presentment discussing only non-governmental actors, saying nothing at all about whether failures by state or local officials played a role in the abuse continuing as long as it did. Second, it assumes the grand jury will fail to offer any meaningful recommendations for reform, the other primary basis the diocese offers for distinguishing past presentments involving non-governmental entities. Third, it assumes the grand jury will not discover any evidence of new or continuing problems that would satisfy a freestanding imminence requirement, as the diocese claims is required. And fourth, it assumes that any names or other specific details that the grand jury votes to include cannot be addressed with more tailored remedies, such as procedural protections to which the state long ago agreed, or targeted redactions, depending on the particular facts and circumstances at issue. To be clear, each of those quarrels is substantively misguided, but the core problem at this stage is simple. The diocese and the trial court's view that a presentment may never address any harms other than those committed by governmental actors is wrong, and each other objection relies on wholly speculative assumptions about the particulars of a presentment that does not yet exist. In short, the state should be allowed to pursue a grand jury presentment on statewide sexual abuse of children by clergy and the conditions that allowed it to continue for so long, and any subsidiary questions about such a presentment should be addressed in the exact manner the rule contemplates, if and when a presentment has been returned. I welcome this court's questions.
Please go ahead, Counsel.
Your Honor, I'll start then. If
Give you a question. Tell us about the pipeline explosion case in 1996. We have some brief mention of it in the briefing. But what were the details on that? Who was involved, et cetera?
Sure, Your Honor. It was a private pipeline. It was run by a company called Texas Eastern Transmission Company, TETCO. And it had been installed, I think, in the 50s or 60s. And so this presentment goes back actually a long ways to try to figure out what had happened. In the 1990s, it wasn't in 1996, I think 1994, the pipeline explodes, I think in Edison, New Jersey. And the presentment looks into how did this come to happen? How did we get to a situation where a pipeline could explode under some people's, near where people were living and put people in danger? So it goes back and it figures out there was dredging of the lagoons in the 1960s and 70s. There were people who were involved in all sorts of activities on the property where the pipeline was over the course of the years. During that time, they look at whether there are potential indictments to be had. Ultimately, they decide, no, there aren't indictments to be brought, but we do want to call attention to the community about the conditions that allowed this pipeline to be a danger to the community. And so they issue a report where they make some recommendations to the government, they make some recommendations to private industry, and that's sort of in sum, I guess, what the presentment says.
Just one follow-up on that. Was there a suggestion there? Was a governmental entity one of the I won't say targets, but one of the objects of that grand jury investigation?
Not really, only indirectly, in the sense that the pipeline company was sort of regulated, and there was a question about whether or not there should be more stringent regulations as to pipeline companies. But there wasn't. It wasn't focused, much like our argument here. It wasn't squarely focused on a public official or suggesting that the source of the problem was primarily governmental. It was actions or inactions, failures or misdeeds, whether criminal or not, by private entities, various people who had potentially been negligent in dredging the lagoons. There were a lot of theories about how it could have happened.
Counsel, I have a question. You mentioned procedural protections. And in Rule 3:6-9C at the end, the due process available to public officials who have been censured is described. What procedural protections were you referring to earlier? And are private individuals or private entities entitled to the same procedural due process protections? And if so, on what authority?
We think they are. We think they should be. I'm happy to talk about why I think the rule, at the time that it was structured the way it was structured, sort of singled out public officials for those protections. But to give a short answer, yes, we think they would get the same protections today. We think it would be appropriate. We've already agreed long ago in the trial court that we thought it would be appropriate to extend those same protections.
When did you extend that?
I believe that's on the record in the grand jury, in the sealed transcript that is now this court has made public in.
Is there any dispute among the parties about that offer?
I don't believe there's any dispute that we've made that offer. I'll hear from it's possible that they not that I know of, Your Honor.
Counsel, you cited Camden too before for the quote that a grand jury may investigate conditions or offenses affecting the morals, health, sanitation, or general welfare of the county, right? How do you define morals in that quote? And what do you see as the parameters around what would be an acceptable grand jury presentment on morals?
So, Your Honor, I think the way I understand that language and what I think it's getting at, and the next line in Camden 2 is helpful too, because it talks about any issues of sort of general public concern to which the community's attention should be brought. I think it's referring to things that the community in its own voice, its own conscience thinks are wrong or problematic. They may not be crimes currently. It's possible that the community believes they should be crimes. I think often that is what moral disputation is about. People who believe that a particular thing is wrongful, and maybe there should be some sort of public oversight of this thing. It may not be indictable as yet, but perhaps there should be more regulation of it, in whether civil or criminal. And so I think that moral in that sense is not getting into anything like telling people what to believe in their heart of hearts. I think what it's doing is reflecting the fact that the conscience of the community, what Chief Justice Vanderbilt identified the grand jury is doing in this kind of reporting function, voicing things that the community thinks are wrong, that it wants to learn from, that it wants to call people's attention to, and to say we're not okay with this, whether it should be a crime or not. I think often they do recommend that it could be, or it could be punished differently. There are all sorts of recommendations they make.
What would be,
Sorry.
what would be an example then of something that fell outside of morals, something that fell outside of what the county's conscience would be?
So I think, there were, to go back to this court's decision in the Monmouth County case, the sale of obscene literature, there were two presented to that case, one about the payment of child support, one about obscene literature. I think in both of those cases, you have a grand jury that's basically saying, look, we're not sure that the way we're dealing with these problems is good right now. And so I think there is a moral valence to that, in the sense that the grand jury is saying, we're a society of laws and our laws should reflect our moral indignation about what's going on here in our community. And so I think that would be an example of a situation which a grand jury is giving voice to concerns it has about widespread private conduct that it thinks is inappropriate, and to which it wants to call greater community attention to, in the hopes of learning from it, potentially spurring, in the grand jury's view, hopefully spurring reforms and that kind of thing.
But what falls outside of that? What does that control? What does that contain? What does that mean? You just gave me an example of what's inside that. How do we know what the parameters of morals are in this context?
Well, I think, again, reading it in tandem with the next line, I think the matters of purely private concern, things that are just not important to most people or many people, that are really a reticulated kind of narrow esoteric concern. There's a dispute among two neighbors, and Joe should be taking better care of his lawn. A county grand jury shouldn't be issuing a presentment on that. Everybody agrees about that. A particular business doesn't seem to be doing a great job with something. I think that's probably a good example. If I could give the court an analogy, I think you do this kind of analysis fairly often when you consider in the First Amendment context what is or is not a matter of public concern. So at some point, a lawnmower company that is engaged in consumer fraud, the consumer fraud gets widespread enough that it becomes a matter of public concern. But I don't read Turf Lawnmower to say that every lawnmower company that isn't perfect all of a sudden becomes a matter of public concern. I think there's a quantum of community impact that leads to the type of community concern that the public affairs or conditions test in Rule 369.
How would you measure that quantum?
Well, I think it's ultimately a balancing test for judges. I think that's what the assignment judge is supposed to do on the back end when a presentment is returned, and that judge can look at the presentment that is returned and say, is this really something that's broad and matters to a lot of people, or is this some sort of narrow private thing that isn't really about the community as a whole, but is about some narrow dispute among people who have some beef with each other.
Doesn't
This
the rule
investig-
itself,
Go ahead.
doesn't the rule itself provide an alternative where it doesn't talk about the assignment judge deciding, is this really only between two people? How broad, how narrow, where do we draw the line? It seems like it says, if it appears that the presentment is false or is based on partisan motives or indulges in personalities without basis, or if other good cause appears, the assignment judge shall strike the presentment either in full or in part. And it talks about the assignment judge being able to review the entire record so that it knows what the grand jury's decision was based on. So it seems like it's not getting at, how to draw a very fine line between how public versus how not public is this. It seems like it's getting at what were the motives of the grand jury? Did it seem like they were acting in good faith? Did it seem and said that they were acting on a partisan basis, or otherwise indulging in personalities without basis? So where do you see that part of the rule coming into play?
So I see it. I guess there are two ways to think about it. You could think about it as targeting a more subjective problem and targeting a more objective problem. I have read it as really targeting an objective problem, but I don't think it's impossible to read it as doing the subjective thing that you're talking about. But either way, I think it's getting to basically the same place, which is if you look at this presentment and you think, geez, this grand jury is just trying to drag people's name through the mud for no reason, or they're just trying to embarrass this business that for whatever reason they don't like. That would be the kind of thing that an assignment judge on the back end would say, I'm not sure about this. And so, that's where you get a motion to strike, and that can get appealed by any aggrieved person. It goes up, and Camden 2 is a great example of this. The mayor of the town thought, or of the city thought that it wasn't appropriate for him to be, impugned by that presentment, and he brought it up, and the court, agreed with him mostly.
This investigation, the proposed presentment turns on an allegation of sexual abuse against children. Do you rely on the term morals in Camden 2 as your basis for conducting this, or others?
No, we rely on general welfare, Your Honor. I mean, I think all of those terms, I kind of read them as a collectivity to address the idea of, to give more, clarity to what is meant by public affairs or concerns, that it's not strictly governmental things, it's things that are affecting people generally. But if you were looking for a term in that list of 4, I think general welfare is probably the one we would point to.
Counsel, I wanted to follow up on the question that Justice Rashali asked earlier with regard to the rules, protections, procedural protections for public officials. And I think in your answer, at the beginning of your answer, you indicated that you would explain why you believe the rule at the time singled out public officials with regard to the procedural protections and didn't mention any private officials or private citizens. So I would like to hear what your argument is for why the rule specifically focuses on public officials.
Absolutely, Justice Pierre-Louis. I think that the 2 sources to look at there are Camden 1 and Camden 2. Camden 1, I think it's pages 66 to 67, and Camden 2, it's really 389, I think, to 381. Those are the pages where the court is talking about, at that time, again, this is in 61 or 62, a concern, I think it's 61, the fact that at that time, the real concern about presentments is that they would be used as a kind of politics by other means, and that they would be used as a kind of way to use the grand jury as a hit job on a particular political rival or someone in public life who someone else didn't like. And so Camden 2 itself brings that to the fore, because it's the mayor and public safety director of Camden who's getting kind of, in his telling, smeared by the way this presentment is written. And so this court in that case is very much alive to the concern, and commentators are too, that presentments will be uniquely used, that public officials be uniquely vulnerable to the problems of a presentment that gets captured by by someone who is just trying to settle local scores. And so I think if I could just tie it back, I guess, to the analogy I drew to the First Amendment earlier, I think that's actually consistent with the way people were thinking about lots of aspects of speech at that time. It's only in 64, we get New York Times versus Sullivan, which says that public officials get, special protection against defamation. It's only in 67 that the Supreme Court says that can apply to public figures too, people who are just have some prominence in the community. So I do think in the early 60s, there may not have been the same focus on the problem of needing to create those protections for public, individuals who don't have a governmental employment, but who are nevertheless potentially going to be mentioned or be discussed in sort of public affairs generally. And so that's why we don't dispute the idea that the rule should extend today to public, to public and to governmental and non-governmental people alike. And that's, if the court were to change the rule to say specific individuals, we wouldn't have any objection to that. I think it's an appropriate clarification of what has always, been kind of understood more recently.
I think a quick follow-up. If a grand jury names a public official in a presentment, there must be enough evidence to satisfy the high standards set forth in subparagraph A and B. Is there a similar standard for private entities and private individuals? And if so, what's the authority for that?
I think it would be appropriate to make clear that exists, whether it's coming in through the text of the rule or through just kind of a fundamental fairness. I think that what the rule is getting at there is a clear proof that the person is actually related to the issue being described. So I think what Camden 2 is talking about, what they're concerned about, is that there's going to be a general problem in the city, and the grand jury is going to say, well, it's all the mayor's fault. And in fact, maybe it's not the mayor's fault. Maybe it's someone else's fault. So here too, if you were to say there's this big problem in, in X, in X parish, it's all the bishop's fault. I think you'd have to be able to show that there actually was a connection. And in any situation where you're saying there's this big problem in the pipeline, it's all the CEO's fault. Well, you'd have to show that it really is the CEO's fault, and not just say, well, the CEO's in charge, so let's blame the CEO.
How does that vary from probable cause?
I think that there are two different. I think the relation is how I read Rule 3:6-9 is that it requires a relationship between the person and the problem being discussed to be a bit more direct than probable cause. I do think that the standard for an overall indictment is quite similar to probable cause. I'm sorry, the standard for an overall presentment is quite similar to the probable cause standard, which is that
this is a higher standard than probable cause.
I read the standard for finding an individual person to be connected to the problem in the text of this court's rule to be somewhat higher than probable cause. It reads to me like more of a preponderance standard or something like that. I do read the overall basis for returning a presentment of any kind, whether or not you're tying a particular person to the problem, that I take to be more analogous to a probable cause standard. That's where I think the words, I think that's the substantial foundation, which I take to be kind of substantial evidence, similar to the way we talk about needing some evidence for a criminal indictment or substantial evidence for an administrative decision. I think that's the standard for whether you get to return and unseal a presentment in the first place. I do think that the rule is giving you a slightly different test for whether a specific person is tied to the problem.
I understand your current argument that even though the rule is referring only to a public official being entitled to this additional protection, that should extend to all individuals who are named in an indictment. But I think your adversary is making a slightly different argument, not based on your generosity of your current position about who should or should not be included, but just based on the plain text of the rule. That I think their argument is because the rule is only granting these both procedural and substantive protections. It's not only procedural, it also says, if a public official is censured, the proof must be conclusive that the existence of the condemned matter is inextricably related to a non-criminal failure to discharge the public official's duty. That, conclusive seems like a substantive requirement and not a procedural protection like the 10 days where the person is given notice and an opportunity to respond. I think your adversary is making the argument, if the rule is only granting these procedural and substantive protections to public officials who are generally acknowledged, including in defamation law, to subject themselves to an increased level of scrutiny, not a decreased level of scrutiny, shouldn't we be understanding that means that the only individual who can be named in such a presentment can be a public official? Because it really would not make any sense for the rule to be bending over backwards to be granting additional protections only to public officials who by definition sign up for additional scrutiny as compared to a purely private actor. So how do you respond to that argument about the text of the rule?
Sure. So Justice Wainer-Raptor, I think it gets back a bit to my colloquy with Justice Pierre-Louis earlier, which is that I think in context and at the time the rule was framed in 1961, I think it actually makes sense that they were focused on the particular problem of presentments that were talking about governmental employees, and that for that reason they went out of their way to create special protections for those people, but that doesn't mean there is no protection or no possibility to say anything about private, non-governmental employees. And so
Camden one, they did go through, as you pointed out, kind of a long history of prior presentments since the colonial era, including about domestic violence, private tax evasion, funding for private hospitals, dance halls, theaters, lots of things. Are there prior presentments in which a specific private individual was called out?
So
Presentment.
In Camden 1 itself, which goes through this litany, that presentment has a private individual. There's a man named Joseph Martino, aka Eddie O'Keefe, who does not have any governmental employment. He gets named in the presentment. The only reason we know his name is because it's in the opinion.
It's two names, actually.
It's two names. That's true. Just better.
We know who he is. Do we have any? I mean, obviously, we don't learn a lot from the opinion.
We don't know not. We learned that he was a guy who was hanging around the jail a lot. And that's pretty much what we learned from the opinion about him. But we know his name and his alias. And we know he's not a governmental employee. So we know enough to know that as Chief Justice Vanderbilt is sort of telling you what the common law is bringing in, he's actually has right in front of him a presentment that names a private person. In addition, he talks about in that opinion the possibility of both public and private individuals being named. So, it does seem to me that it's on the court's mind at that time that there might be presentments that name private individuals like that particular one, and that would be permissible. I don't, I think the other, so I think the other reason that it just makes sense is to get back to what I was talking about with Justice Pierre-Louis, which is that I think in the context of 1961, the focus was on those particular people, the governmental employees. And as the Tort Creditors Committee points out in their brief, I think it's footnote 6, there are times where this court's directives and other rules kind of create a different, create slightly different protections for governmental and non-governmental employees based on a perceived difference of risk that the governmental employees just are going to get, they're going to be susceptible to more kind of,
Would it be reasonable for someone reading this rule before this case came up to view it as relating to governmental entities? And I'm getting away from the research, but I'm talking about people reading a court rule and trying to assess what this is all about.
I don't think that New Jersey's court rule would give the same sense of being exclusively about governmental entities that some states' court rules are. So there is, and the literature goes into this, the states take different approaches on this. And there are states that say presentments are only for governmentally sourced harms. But I don't think that New Jersey's court rule would give that textual sense. I think
maybe not that level, but just looking at the rule in isolation, leaving aside how it may compare with other states.
I think the most important textual evidence in the rule is the phrase public affairs or conditions. And I think that phrase very clearly denotes something broader than just governmental problems.
Can we look at the rule alone, or do we need to look at it in tandem with the case law of this court?
I think you should look at it in tandem with the case law of this court. And the case law of this court itself brings in a third source, which is the common law and the presentment power as it was understood prior to 1947, because Camden 1 says that the 47 Constitution is bringing in the common law, the very, very broad common law presentment power of the grand jury. So I think you have in front of you not just this court's precedents like Monmouth County, which actually reinstates a presentment involving the sale of obscene literature in the county, obviously something that doesn't emanate from a governmental source.
One hopes.
And then one hopes. And then you also have all of the presentments that Chief Justice Vanderbilt recounts in Camden 1, which are in that kind of common law tradition. And, going back to, colonial times, you have presentments that do address individuals who are not governmental employees. You would have them addressing problems that arise from non-governmental sources. And so I think in New Jersey, you would look at our rule and say, this is a rule that grants the grand jury broader power to speak about things that affect the community generally, things that are to which the community's attention should be directed because they are a matter of public welfare, whether or not the principal source is governmental misdeeds or non-governmental misdeeds. And so I think all three of those I think that the text public affairs or conditions, I think the precedent, Monmouth County and the like, and then the common law that Camden 1 says is coming in with all of this. I think all three of those principles point in the same direction.
So, Counsel, I gather you'd see no problem with their presentment about the impact of social media on children and subpoenas issued to TikTok or Twitter or Facebook or any of the others, right? I gather you'd say that that's fine.
I think that's right, Your Honor. I think you could commence a presentment on a topic like that of general public concern. I think if there were, I think that's right. Again, you'd have review on the back end if it were.
And what if that topic was the influence of TikTok only?
Well, again, I think you could, if the concern was there's something particular about this platform that is causing particular harms to children, I do think that it would be legitimate for the grand jury to venture into that territory. If on the back end, the assignment judge reads the presentment and thinks, I don't understand, seems like they're just going after TikTok for no reason. And, they should have been going after Instagram because Instagram seems so much worse. You could imagine a scenario where an assignment judge says that they want to strike this, but I don't think that you get to say at the front end, the TikTok presentment can't even start, which is what the trial court said here.
If we agreed with you that the review is only after the presentment has been presented to the assignment judge, but before it has been publicly released or published, then would we have to get to any of the other questions? Wouldn't the holding just be there is no review until a presentment is actually presented to the assignment judge. And then all of the other particulars can be worked out in the context of that particular case where the assignment judge is actually reviewing a specific presentment and therefore knows if it mentions only a private individual or only one of two companies or whatever the question is, rather than in this case where there is no actual presentment that has been presented or that necessarily will be presented ever.
Yes, Your Honor, I think that is an entirely correct and coherent opinion to write. That's point one of our brief, is that this is all hopelessly premature. I think
that was really the main focus of your point before the trial court, correct?
Well, before the trial court, we also joined issue on the sort of the trial court's substantive objections. But the problem with joining issue on those substantive objections is that they're all entirely speculative. The only one that I think you could really reach in any way is this question of, could you ever say anything about a non-governmental actor? Because the one thing that's really hard to deny is that the contemplated presentment would say something about the Catholic Church. So if the diocese is correct that there's a bright line rule that it has to be only from governmental sources, then I can understand conceptually relaxing the rule to say, let's just do that at the front end. But that's the only issue in this that I think even can be logically squared with doing it at the front end. I don't think it's technically correct under the rule. Of course, this court can relax its rules. It can give guidance. We all take this court's guidance and admonishments very seriously, regardless of the posture of the case. So I think this court certainly could speak further than just it's premature, but logically speaking, you're exactly correct, Justice Wayner-Apter. It is formally just entirely premature.
Counselor, though, if we go to the rule, and the rule talks about striking presentments that are false, based on partisan motives, indulgent personalities, or other good cause, I want to focus on based on partisan motives. Doesn't based on partisan motives imply something directly related to the origin or initiation of the presentment? Are you saying that if there is significant evidence that a presentment originates out of or is based on a partisan motive, that we would have to allow that presentment to go all the way through until we stopped and said, in the very beginning, you said you were doing this for partisan motives, so none of this should have happened?
So I think, Your Honor, I mean, of course, we would disagree substantively. There's anything like that going on in this case. But as to just the procedural question of whether a court could ever engage in that kind of front end stop the presses approach, I think that's inconsistent with how we generally think about the grand jury. And indictments are an equally good analogy for this. I'm not aware of a case that says you get to go into court and say, you may never pursue any indictment on anything in this general sphere of topics, no matter what the grand jury thinks, because I have a theory about why the effort to even consider an indictment, to even investigate, is problematic. I guess I don't want to fight too hard the principle that somewhere at the extremes you could have something like that kick in. I think it would probably kick in as to some separate action that someone would have to bring, or an attack to a particular, I'm just thinking hypothetically here, like an attack at a particular subpoena or something. So I don't even think it would work. I've never seen a case where you just get to say, we won't even allow the grand jury to investigate an indictment. And I think the rule extends to a presentment too, because we think there might be at the front end some sort of bad motive. I don't think that really works. And I think the reason it doesn't get unsealed until the assignment judge does the review is wholly sufficient to guard against those concerns, because of course, if it comes back and the assignment judge says, you know what, my suspicions were right, this looks like it's entirely a partisan affair, then the assignment judge can strike it in full or in part, before it's unsealed, and there can be a review by anyone who disagrees with that.
And it goes back to your argument that a lot of this is speculative. And with any grand jury investigation, am I correct? There's really no telling what the investigation will reveal, what the grand jury will determine at the conclusion of that investigation. In criminal cases, it could be the case that a grand jury investigation begins with one theory or one criminal offense in mind, and at the end of the grand jury's investigation, there's a different criminal picture that results. So I think it kind of goes back to your argument that it's really difficult to speculate as to what a presentment, if 12 grand jurors even vote on a presentment, will look like, and trying to determine how to assess something that has not yet come into existence.
I think that's exactly right, Justice Pierre-Louis. I think that's a better encapsulation of the answer I was trying to give to Justice Cobb.
Does that weigh against a look at the merits at this stage?
I think it does. I think, again, I just to pull apart this one merits argument that is I suppose easier to reach, is just this bright line rule they urge that there is no way to ever say anything about a non-governmental actor. That, I think, is incorrect to reach technically, but somewhat more administrable at this stage. I think everything else truly is entirely speculative, and there I would have trouble even explaining to the court how I think that review should work.
Well, isn't there another piece to it as well? It's the allegation itself of sexual abuse. It's not simply a non-governmental actor. No?
Well, right. I mean, the topic, the anticipated topic is sort of widespread sexual abuse of children and how it was allowed to continue unabated for such a long period of time. And so I think that if a court thinks that that could never even be mentioned in a presentment, I suppose that's administrable on the front end in a way that—
Is it administrable on the front end? Because you would be saying, here's hypothetically what could be. So tell us if this is proper or not. And if you are correct in the point that you've consistently made since the trial court, which is we don't know how this is going to, whether there will be a presentment, if we don't know what it's going to say, if there is, it's premature to rule on this. How can you peel off one issue out of that and say, we're with you, we're not with you?
I basically agree. So I'm not trying to argue against myself too heavily here. I am just trying in candor to the court.
If you're going to argue against yourself, we're going to give you two names, like the guy in the.
So I do think it is all truly premature, and so that's why we think that you absolutely can just reverse on prematurity. That's point one. That's an argument we've made throughout. We're sticking to it. It's we think 100% correct. If the court, all I'm trying to say is that if the court wanted to go past that, I think you could only go a little bit past that. I think it'd be very hard to go much past that, but I agree with you. It's a little hard to go anywhere past that. And so our main position is it is just simply premature to be doing this review.
Doesn't that then mean that you're asking for an invitation to come back again? You've heard the arguments. You know they're coming. And it's the context of whether this relates to public affairs and conditions. Topic irrelevant to that, or should it be addressed as well?
I think that, well, again, this gets back to my kind of alternative argument, which is that if you wanted to go past it, I think it would only make sense to go past it a very little bit to say there is no bright line rule that you could say nothing about a non-governmental actor. That much, I think, is helpful because it forecloses one big conversation on which most of the Diocese of Camden's objections rise and fall.
But I think if we were to any consideration of, is this or is this not a matter of public concern, is very hard to do in the abstract because it's all about exactly how you frame the matter. And the rule seems to suggest that the assignment judge has an aid as the minutes and the record of the grand jury. And so the assignment judge doesn't only have what's presented, but really everything that went into it in order to assist the assignment judge in deciding, is this a matter of public concern? For us to just put one phrase and say this is inherently a matter of public concern or not seems speculative no matter how you slice it, because it's all in exactly how you define the phrase. And then the litigation ends up being, well, is this really just that exact phrase, or is it some other version where we just don't have any content?
I agree with you again, Justice Wainwright. But I think to Chief Justice Radner's point, I think it is always, a court is always in a better situation. I would think, when it has the concrete, presentment or whatever the instrument that's under review is in front of it. And so I do think that it is hard to engage in any of this analysis when we're dealing entirely in the abstract. So I think, again, it is the most correct under the rule to simply reverse on the prematurity ground. I think that's entirely logically, not only, I think it's logically correct and sound under the rule. Again, I mean, Chief Justice Radner, I do understand your point, and I am agreeing that there is possibly one issue that would not be inconsistent or would be logical to reach or wouldn't be illogical to reach. But I do agree that it's all quite premature, and that the best way to do this is the way Rule 3:6-9 sets up, which is that you get an actual presentment and then you get to review it in the concrete context in which it's.
When that happens, take us through the procedural. If the assignment judge reviews it and strikes it or doesn't strike it, and there presumably is going to be an appeal of that, or if there is, what is the standard of review? Is this an interlocutory appeal as to which the one party or the other would go to the appellate division on an interlocutory basis? How would it work?
So I think so. The key section of the rule is section E, and it does suggest an abuse of discretion review. It's a broad right of appeal. It's available to anyone, not just the state, but any aggrieved person, including any member of the grand jury making the presentment, which I think reinforces the idea that this is quite premature, because the rule anticipates there will be a member of the grand jury who might be appealing something. And obviously here we have no such grand jury, because this was stopped before any presentment could be sought. But I think that on matters of pure law, I do think there would still be space. I know that the rule does say abuse of discretion there. I think on matters of pure law, it would still bring in de novo, the way this court has elsewhere described abuse of discretion review, or a trial court can abuse its discretion by simply getting the law wrong. And so if you had a trial court that said, you just can't have this at all because you can't say anything about any entity that's not.
That's a legal determination subject to de novo review.
I think that would be subject to de novo. But as to a particular person where where the assignment judge says, I just don't see the adequate foundation as to this person, therefore I think you need to redact that person's name, I do think that would be up on abuse of discretion.
Mr. Zuckerman, I want to come back to what you're asking this court to do right now, because I understood from your brief that you're arguing, first, the prematurity argument, and second, that this is indeed a matter of public affairs. And now it sounds a little different, and I'm looking for you to clarify. Are you simply asking this court to say, premature, let us do our thing, we can conduct an investigation and possibly issue a presentment as relates to non-governmental action, and that's it? Ignore everything else? Or are you saying we need to peek a little bit at the general subject area, not the facts? No one knows where the investigation will go. And it's not simply enough to say, or that you are not simply asking for this court to say non-governmental action can be reviewed.
So Chief Justice Radner, it is the first one. I think that we are primarily, we are making, I guess, two independent arguments, one of which is a fallback to the first. My frontline argument to you is that it is highly premature, inconsistent with the rule, for the trial court to have short-circuited this process before it could even start. And so for that reason, this court should simply reverse and remand for the process to go forward, possibly clarifying along the way that presentments can sometimes talk about non-governmental actors too, but otherwise just reversing and remanding. In the alternative, if you were inclined to peek, which is what the trial court, I think, thought it was doing, then I have a lot of answers to why I think that nevertheless you should reverse and remand and allow this process to go forward.
But what would we be peeking at if there is no presentment? We'd be talking about a hypothetical presentment, and it's not a judicial function, it's a grand jury function.
I think that's the problem. I think that's a fundamental flaw with the trial court's approach, because it tried to peek, but it was peeking as to something that was entirely speculative.
I'm missing something. Or was this all about an allegation of longstanding sexual abuse? Why is that not part of your argument as well?
Well, it is about
The details, not the particulars as relates to an incident, but the subject itself. Please.
So I think it gets back to, at a high level, it's about widespread child sexual abuse and the failure to curtail it for a really long time. I think the reasons that the trial court gave and the reasons I've heard the diocese press for why you could stop this if you peaked are all reasons that are not administrable at this stage because they're entirely speculative. So I think at that very, very high level, the only argument they have is this argument that you can't say anything about private, non-governmental activity. Everything else is, the speculation that you won't say anything about, you won't have any helpful suggestions for future reform. You won't say anything about how the government might have intersected with this. The grand jury is going to vote to name names, and those names are not going to be, already permissible to be named for some reason. I mean, it's a series of conjectures about specific things about the presentment, not just Chief Justice Radner, the sort of high level, conceptual idea of the basic topic that I hear them to say as their main, as their objections, their sort of subsidiary objections to why, if you peak, you should say no. And those are the things that we think are both unfounded, but also just, entirely speculative and kind of impossible to adjudicate at this stage. So I guess
the cases that, obviously the main cases, Camden, Monmouth, et cetera, but in the cases you've read, has there ever been an adjudication of the propriety of a grand jury presentment before the presentment is issued?
Not that I'm aware of, Your Honor.
Never been a challenge.
I agree with that. I believe there has not been a challenge and has never, it is possibly probative that there has never been a challenge because nobody even thought you necessarily could do a pre-presentment.
Especially because
challenge.
presentments have been used in New Jersey since the colonial era, as the court discussed in the first case. And you're saying none has ever been before the presentment was issued. And there is this whole process for how review happens after the presentment is issued.
That's exactly right, Justice Winger-Apter. No one has ever identified a case in which there was this kind of pre-presentment review.
So what I hear you saying in response to the Chief Justice is the reason is to be intellectually consistent. The reason you can't cut it off now is the same reason you can't really peak. Is that right?
I think that is basically right. Yeah, I think that's right, Justice Hoffman. All of their arguments against cutting it off are things you would not just be peaking, you would be inventing a story about what it looks like once you peak. And that's the problem with that kind of approach to pre-presentment review. It's all of these conjectures about what this presentment is or is not going to look like if the grand jury even votes to issue it in the first place.
So if you're not going to weigh whether you can cut it off or not, you shouldn't really be weighing whether you can peak.
I think that is. I think that's right. I mean, it is this court's own rule. So I guess what I'm not trying to fight is that this court has authority over its own rules and can tell everyone, even if it's technically advisory, what its rules mean. And so if there's a dispute among the parties about does public affairs or conditions just mean the government, I don't think it's improper for this court to tell us that no, it doesn't just mean the government. It can mean private actors too, consistent with Monmouth County, consistent with all the common law, consistent with the other cases. But I agree. Otherwise, I think basically there's no, as to the actual dispute in front of this court, I don't think that there is any real, I don't think it works to try to adjudicate it at this premature stage because it is based on entirely conjectural theories of what would be wrong with a presentment as they understand, as they forecast or expect the presentment to look. And that's, in addition to the legal problems with their arguments about that, I think that's just totally conjectural.
And you've referred to it as an advisory opinion, but technically anything, regardless of whether it was an advisory opinion, anything the court would say would be dicta because there is no presentment here. So anything the court would say about presentments in general or what one might say in the future would not be concerned with a specific presentment in this case.
That I think that's right, Justice Wayner-Apter. Obviously, the lower courts and we take your dicta very seriously, but I think that's right. It would be dicta.
So if the court were to say that allegations of longstanding sexual abuse of children is a matter of public affairs, you think that's an inappropriate step?
I think that is correct. I think it is appropriate in this court's ability to, first of all, this court obviously is not bound by strict jurisdictional rules the way a federal court might be. So I think this court can give essentially some advice to the lower courts in the context of this dispute. I don't think it would be improper. It is your rule. So I don't think it's improper in any way, but I also think it would be wholly proper to say this is entirely premature. And to Justice Wayner-Apter's point, I do think it would technically be dicta because there is no presentment in front of you, but there is a dispute, and it would be at the, at worst, very, very probative dicta because it's dicta that's been in a very, an entirely litigated case with parties that do disagree about this. They just don't yet have a ripe dispute in front of you.
I'm not assuming you don't like being here because you argue before us a lot, but if we were to take some sort of guess as to what the future holds and we were not 100% right, you're back here anyway.
That's correct.
Or if there's no presentment, then you're not back here anyway.
I think that's also correct. Yeah.
He's smiling at that prospect.
Counsel, let me ask you a question. Given your experience and given the other cases that we have to rely upon, is this case unique in terms of the preview that existed before this was engaged in, given the press release, given the existence of the Pennsylvania situation? And did that sort of prompt a difference in this case versus those?
I don't think we know whether it's truly unique. I agree, Justice Noriega, that it accounts in part for how we're here, that there was some awareness that the state would be seeking a presentment because there was a press release about it. So I think that can have some explanatory power, but at the same time, if you look back at other presentments, it's not as if there weren't potentially signs to those people too that there might be something coming. I mean, when people start getting called in to testify about obscene literature in Monmouth County, they may have a sense of what's coming, they may not, the pipeline again. So I just don't think we know. I don't know of a case where there was or was not a press release or exactly what, as a matter of historical fact, people knew going into the other ones. But as Justice Wayner-Apter points out, it's a really, really long history of presentments. A lot of them did talk about things that people, for whatever reason, might have wanted to stop before they even started. And we have no example of anyone being allowed to come into court and do that, or any dicta that says, but you could come into court and stop it before it starts either. And I think that too would be probative if you even had a judge ever contemplating that happening, but we've not seen any such dicta.
Other questions, anyone? Anything you'd like to add, counsel?
No, thank you, Your Honors.
Thank you. Mr. Shalom.
May it please the court. I'd like to address 3 issues, and I'll rely on the state for some of them, but I'd like to talk about the kind of scope of grand jury presentments, the due process protections, and then the concept of an imminence requirement. And at the end, I'll also talk about the remedy question that you were just bantying back and forth about. So I'm largely going to rely on what the Attorney General has argued in our briefing on the argument that which refers to public affairs and conditions is broader than that which concerns public officials. But let me just take a stab at saying a little more about footnote 6 in our brief, because Justice Wayner-Apter, you asked a question which you appropriately noted that in defamation law, public officials, public figures are given fewer protections than private officials. But that's not universally true. And in footnote 6, we talk about the phenomenon of private citizen complaints in municipal court. And so like the kind of genesis of this rule being to protect public officials from presentments being used as a form of politics by another means, in Mr. Zuckerman's words, in the last decade when Governor Christie was governor, there was someone who brought a complaint in municipal court charging Governor Christie with crimes related to Bridgegate. And it raised questions for a lot of people about whether that process was being manipulated for political ends. And the Supreme Court put together a committee that proposed a rule, and a rule was adopted, and the rule provided greater protection for public officials, for candidates for public office. So it's not unheard of in our law that government officials would get additional protections, which of course doesn't mean that non-government officials get no protections. On the due process question.
Before you leave that, is it your position that, as amicus, that the rule should provide equivalent protections to private and public figures?
I don't know that as amicus we have a position on that rule. I think that does make sense, but we know that in this instance, that has been offered. And Chief Justice Ratner, you asked whether there was any dispute about that. I will note that it's in the Attorney General's brief, it's in our brief and several other amici briefs, and in the response to those briefs, the diocese doesn't.
We'll find out in a moment.
We will find out in a moment, indeed. I think that makes sense, Justice Patterson. I think there are good reasons for those protections to extend. So let's talk about the due process. I think it's clear that all of it happens after the fact. But I want to just say a word on that. And Justice Hoffman, it was your question about social media that got me thinking about it. That you cannot stop a presentment before it starts doesn't mean that every subpoena a grand jury issues is valid. And so one could think about NAACP versus Alabama, where the question was whether the state could get access to the NAACP's membership rolls. And the NAACP said, look, we have a First Amendment associational right that is infringed by that subpoena. And just responding to the subpoena would harm our associational rights. And so First Amendment challenges can be brought on a kind of an as-applied subpoena by subpoena, item by item basis, which is wholly different than the idea that you can cut the grand jury off at the outset.
I think that's right. And it's an excellent point, but I must admit, I still struggle with the language of based on partisan motives, and that a determination cannot be made whether a presentment was initiated, the process was initiated based on partisan motives or not. Because that's the language, based on motives, partisan motives. I struggle with the idea that we would have to watch a presentment go through when there was ample evidence that there were partisan motives that initiated the process.
Well, so let me first give a kind of non-response response, which is to say that in this case, there have been 3 different attorneys general and acting attorneys general who've presided over this process. It was initiated by Attorney General Graywall, but then acting Attorney General Bruck, and now acting Attorney General Rotolo. And so it's hard to make that assumption in this case.
I'm not making, but we decide things here. We make decisions, not about what's right in front of us sometimes, but what's around 2 or 3 corners. And I think it's our responsibility to get an understanding of what the impact or the effect of our decisions may be around those 2 or 3 corners.
And that's fair. And I'll be talking about those corners when we get to the remedy question. But let's just say this. I think in general, it is very hard to make a determination about partisan motives with so little information until you've seen the presentment. And that's exactly why 3:6-9 provides a mechanism after the fact for an assignment judge to make that determination. But it is, I think, too often too speculative to do so because a press release seems incendiary or something. I'm saying a theoretical press release, not the one.
Unless there is more information, right? It's often impossible because there's not enough information, but there could be instances in which there is information that there was a partisan motive behind doing something, right?
I suppose it's possible that such a case could exist. But let me take issue with one more
The
piece.
rule itself make it seem like you can't decide that until you see the presentment, only because the language of the rule says if it appears that the presentment is false, comma, or is based on partisan motives. So the whole thing you're asking is the presentment based on partisan motives? If the presentment does not exist, then it's hard to know whether it is based on partisan motives.
I think that textual reading is totally right. And I want to just turn back to Justice Hoffman for a second on the idea that, because you've been asking that it was initiated based on partisan motives, but that's actually not what the rule says. The rule says that the presentment is based. And so that suggests that not just its initiation, but it's kind of the entire process was based on partisan motives. And I think that is impossible to tell.
Do you view the term partisan, which we see on the news, politicians say whatever the other side is doing is partisan or nonpartisan. But do you see that as a traditional political meaning, or is that, in other words, one party versus the other, a fight over an election issue, whatever?
Yeah, I don't
see it more broadly.
I see it more broadly. I don't think it's just Democrats picking on Republicans and vice versa. I think it could be, this person treated my kid poorly, so I dislike them and I want to sully their good name. I mean, also those things.
It could be a local issue that doesn't necessarily have a political overtone.
I think that's right. Certainly, like party politics, political overtone. Okay, briefly on the question of imminence. At the trial court, it was said that the history that the Attorney General seeks to write is anything but imminent. And in their briefing, the diocese makes the assertion that child sex abuse from clergy ended in 2002. I think there are common sense reasons to reject that, but there are other reasons to reject it as well. Delayed disclosure is so well accepted in the literature. This court in JLG, in Chief Justice Rabner's opinion, said that that is a kind of well accepted principle. Our legislature has accepted the idea of delayed disclosure in its extension of statutes of limitations. So the history of contemporary child sexual abuse has yet to be written. But even if it weren't that, we know from the bankruptcy proceedings that the diocese itself takes the position that its behavior today, its policies today have an impact on children. They can protect children by the things that they do. And that's why they agreed to the child protection protocols. Were that not the case, that whole process would have been meaningless. And so the idea that nothing that will be in this presentment can have a contemporary impact is simply belied by common sense, by the literature, and by the behavior in the bankruptcy court. So let me now turn to the question of remedy, and this might be the only area where we part company from the Attorney General. Because, Chief Justice Rabner, to your questions, I am mindful of the fact that the press release that we've been talking about was 6 years ago, was issued 6 years ago. The trial court argument was 4 years ago. And I think there is real harm in waiting a long time to get back here just to suss out what things are. And I actually don't think, I think it was your question, Justice Hoffman, I don't think this is a situation where if it's premature, you can't say anything else. And here's why. The court certainly can, Mr. Zuckerman laid out a series of ways in which the diocese argument relies on speculation. It speculates that it will only name private officials. It speculates that it won't call on public policy changes for the government. We don't know that. We can't know that. But we know what arguments the diocese has advanced. And if the court thinks that as a matter of law, those aren't true, which is to say, if the court thinks that the sexual abuse of children over a long period of time is within the ambit of that which refers to public affairs or conditions, you can say it now to provide guidance to lower courts. And it might not prevent another trip here, but it might. We are in a situation where we have 3 published opinions from this court over the course of 70 years that deal with presentment. So there's this real paucity of jurisprudence.
You see the tension, which I think the AG is very candid about, between saying nothing should have been said or done or ruled upon before a presentment, and then saying, okay, it's premature, but we're just going to look at some thematic issues based on a press release by the AG 6 years ago and say, well, if it's that, then here's our ruling about it.
To be clear, Justice Patterson, I don't think you need to look at the Attorney General Graywall's press release. I think what the opinion that I would ask you to write would say is, first of all, we reverse and remand because Judge Warshaw was wrong to take it up in this posture. That's the prematurity argument. Additionally, having reviewed the arguments of the diocese, we determine that their reading of the scope of permissible presentments is incorrect insofar as it is limited to government employees.
That is reaching the merits in the absence of a presentment. And it may be, and it obviously the integrity of the grand jury process allows the grand jury to take this in whatever direction it deems fit. So we would be saying, okay, but if it's this, it's okay.
No, I think what you would be saying is if it's this, it's not forbidden. And that's different than saying it's okay. This would still, under Rule 3:6:9, this will still go to the assignment judge if a presentment is returned. Prior to release, it would go to the assignment judge. And you can't bless it beforehand. But what you can do is say, assignment judge, when you're looking at this, these are the things that are not inherently forbidden. That doesn't mean it's acceptable. It means it's not inherently prohibited.
Mr. Shalom, and perhaps my questions to Mr. Zuckerman were not focused and sharp enough. Is it an open question under our law, under the precedent of this court, and I'm thinking of Monmouth in particular, that a subject, just the subject of longstanding sexual abuse would be beyond the permissible confines of what a presentment is? Because in Monmouth 1, we had a presentment that the court reversed the assignment judge and said, this shall be made public. And it related to sale and publication of obscene and indecent literature. If that was an appropriate subject, forget about the details, wouldn't longstanding sexual abuse also as a subject be appropriate under our law as it exists today?
That is exactly how I read the law. I think that is also consistent with how the Attorney General reads the law.
But Monmouth, there was a presentment at hand. Am I right about that?
That's right, but
No,
that,
just let's be, just.
that is
there was a
absolutely correct.
presentment.
There was a presentment.
This was not speculative. This wasn't a good educated guess by the court. It was the real deal.
Correct, but then we expect parties, meaning law enforcement and assignment judges and subjects, to be bound by that precedent, to read that precedent and make certain interpretive decisions based upon it. And to the, I think the Chief's question, which I endorse the affirmative answer to, is if pornography in Monmouth County is an appropriate subject, so too is widespread sexual abuse. Unless there are further questions, we'd ask you to reverse and remand.
Thank you.
Thank
Mr. Levinson.
May it please the court. The Diocese of Camden agrees that sexual abuse is evil, but we are not here to determine liability for past sexual abuse. We are here to decide a legal issue, whether New Jersey law authorizes a grand jury to issue a presentment against private individuals or private entities. There have been false negatives about this narrative, about this litigation, which compel me to clarify that the diocese has never sought to prevent the state or its task force from investigating allegations of clergy sexual abuse or from bringing indictments against those accused of illegal conduct. Nor is this litigation an effort to hide illicit conduct or to circumvent legal or moral obligations. To the credit of the state and the church, we worked together 23 years ago to confront this conduct, resulting in a 2002 Memorandum of Understanding by which the church was to report any violations to the state, and the state was to bring criminal actions if warranted. Despite the success of the MOU, the then Attorney General instead reacted to the publication of the 2018 Pennsylvania Grand Jury Report to replicate that plan in New Jersey. But Pennsylvania's grand jury was convened under Pennsylvania law, different from New Jersey's law. There was no prior MOU or similar agreement. That grand jury report resulted in amendments to Pennsylvania's statutes of limitations for sexual abuse, which have already been done in New Jersey. Rule 369 simply does not authorize a grand jury to return a presentment critical of private individuals or private entities. New Jersey only authorizes a presentment related to the administration of government by public officials. As for misconduct committed by private individuals, the state has the full force of the criminal justice system for prosecuting unlawful conduct. And survivors in New Jersey have the full force of the civil justice system for redressing culpable conduct. The state is incorrect in claiming the contents of this proposed presentment are hypothetical. The state has already indicated several times that the presentment will be modeled after the 2018 Pennsylvania grand jury report. This court in Camden 2 stated that the first obligation of the assignment judge is to determine whether the subject matter of presentment is appropriate. There is no need to wait for a grand jury to return an unauthorized presentment when this legal issue can be confronted now. This court also acknowledged in Camden 2 that presentments are particularly unfair because they accuse without any opportunity to defend. As a result, the court amended the rule to provide due process protections for public officials. One, requiring a connection between the official's public duties and the condemned matter, and two, affording the opportunity for the public official to appear before the assignment judge to present additional evidence prior to publication. If the court intended grand juries to be able to name private individuals in a presentment, then why would the rule provide due process protections only for public officials, leaving private individuals with no protections whatsoever? Limiting presentments to public officials clearly indicates the true purpose of presentments, to ensure the sound administration of government, not the Catholic Church. This court concluded in Monmouth that the subject matter of a presentment must be imminent. Clergy sexual abuse is not an imminent matter in the diocese. For 23 years, the MOU has been effective. The MOU required the state to revisit it in 5 years or as the need arose thereafter. Yet the state never did so. Why? Because the MOU is working. It was only just weeks after the Pennsylvania grand jury report was published that the state first claimed that they needed to revisit the MOU and they needed a grand jury to do so. The state's task force investigation has resulted in only 2 indictments for child abuse. One of those priests was convicted for abuse that occurred in the 1990s, and the other was acquitted. If this court expands the scope of a grand jury presentment to include private individuals and private entities conducting investigations in secret under the sole influence of a prosecutor with no opportunity to present a defense, the grand jury's authority will be unlimited. The presentment proposed by the state would call attention to long ago conduct by private individuals that impacted only a fragment of the population. The proposed presentment has no connection to the administration of government. Presentments were never intended to call attention to private conduct within private entities. We ask respectfully that this court affirm.
Are you completed with your opening statement?
Pardon me?
Your opening statement is complete?
My opening statement is complete.
Can the court rule override?
Was it under 5 minutes, by the way?
Just a tad, just a tad. Can a court rule override precedent of this court, a Supreme Court decision?
Well, I think the court rule is consistent with the precedent of this court. Because when you look at the court rule.
I just want to ask, generally speaking, if there's a perceived conflict, which prevails?
I'm sorry, say it again, sir.
If there's a perceived conflict between a court rule and a Supreme Court case, which prevails?
Well, I think the court rule, because the Supreme Court precedent was from the 1950s. this court rule was changed after Camden 2 to include what it includes with regard to public officials. And it has remained, Rule 369 has remained that way for, I don't know, 50, 60, 70 years.
So
So I think I think you all have acknowledged that what's in the rule is consistent with case law.
So you've pointed out, of course, as the trial judge did, that the church is not a public entity, that priests are not public officials, and that therefore this presentment is inappropriate. Don't the facts of Monmouth, the essential facts of Monmouth, say otherwise? There you had an entity that was not a public entity, officials who were not public officials, and a presentment. This court directed that presentment should be disclosed. How does that factor into our understanding of the rule? Are you saying that should be ignored?
No, sir, not at all. I have no problem with Monmouth at all.
But Monmouth dealt with non-public officials and entities.
It didn't name any public officials or entities.
How do we know that? In your brief, you make the argument that the Monmouth presentment is not available. So the only information we have with regard to the Monmouth presentment is the court's opinion in that case. But then later, as you just noted, you state, well, no private entities or private individuals were named. How do we know that? The opinion itself indicates that the grand jury heard testimony from representatives from 3 distribution companies and a number of dealers, seemingly businesses that were in the business of distributing these obscene materials that were the subject of the presentment. So how do we know that? I think that's part of your argument in distinguishing this case from Monmouth, but I genuinely would like to know how we know that private individuals or private entities were not named when we don't have the presentment, but we know that such individuals did go before the grand jury and testify.
Well, we know because the assignment judge struck the presentment. We know that. And we know that the assignment judge said it was vague as to the distributors and dealers' responsibility. The assignment judge wanted to name names, but
their responsibility, but not necessarily the distributors themselves.
Well, the goal here is obviously to condemn the Catholic Church and to condemn priests and bishops. So in Monmouth, there was no names mentioned whatsoever. So I don't really understand why the question is, because the result of Monmouth, they did not name names. They were dealing with a condition in the county, which was a broad condition, affected everybody. At the newsstands, when they used to have newsstands, there was pornographic literature facing old, young, children throughout the county. So the grand jury felt that that was inappropriate. And what they did is they instructed municipalities to enact ordinances in order to deal with that problem. That's how the result occurred.
Does your objection go beyond the naming of names, though? Because you asked that this grand jury not be impaneled altogether to conduct this investigation because these were not public entities and officials.
Right. That's our position, that it was right for Judge Warshaw to do what he did. This is a very unusual and
Isn't that at odds with Monmouth, which said this should be presented to the public, this matter relating to non-public officials, non-public entities? Doesn't our case law already stand for that?
Monmouth doesn't stand for non-public officials, non-public entities. They talk generally about the fact that the pornographic, obscene literature was available to everyone. And they wanted the world to know that the availability to see those walking down the street was improper.
But the availability of those obscene and pornographic materials stemmed from the private entities that were making those materials available, which is a reason why those distributors and dealers went before the grand jury and testified.
And doesn't it specifically say that it was about, quote, the sale and publication of obscene and indecent literature?
I'm sorry, did you say that again?
Supporting what Justice Pierre-Louis just asked, the case also specifically refers to, quote, the sale and publication of obscene and indecent literature. So it's not just that when you walk down the street, you could see it. It was that it was being sold by particular entities that were not the government.
You know, I would answer that with this. When you look at the Supreme Court decision in Monmouth, they spent, it's only 4 pages long. And maybe less if you take away the who's representing the parties and whatever. But it's a very brief case, and we don't have the presentment. And it talked about imminence, which is another thing I'll get to in a minute. But what it spent time on, when you look at it, is a whole side of a page on quotes from Camden 1. And look at what those quotes were. Don't have it right here, other than to say that the quotes were maintenance of popular confidence in government, the sound administration of government at every level. That's what they were talking about. Now, if they had a problem, if the Monmouth Court had a problem with what my argument is, then they wouldn't be quoting from Camden 1. They would be making a diversion from Camden 1 and saying, well, we don't agree fully with Camden that it's all about the sound administration of government. It can be something else. And what resulted in Monmouth was a direction to the municipalities to pass ordinances. It also criticized the police.
You're talking about the presentment in that case.
Pardon me?
You're talking about the presentment in that
Yes.
case.
So let's go back to Camden 1 then. And Justice Wiener-Apter read for you some of the examples that are detailed in Chief Vanderbilt's opinion.
Right.
Controlling dance halls, theaters, selling liquor, and so on, which are non-governmental entities, non-public officials. And then the court said, as one reads these presentments, the conviction grows that they have been a great force in bringing about many substantial improvements in public affairs. How do you get from that, and from that concept, which is repeated in Monmouth, to the position that an investigation that relates to non-public entities and non-public officials cannot be the subject of a presentment?
Well, if we look at Camden 1, you're talking about his Chief Justice Vanderbilt's recitation of presentments. It spent about 18 pages.
And his endorsement of them.
I disagree with that. I disagree with that, Mr. Chief Justice. I disagree with that he endorsed that. I think that was a historical rendition of presentments. It was like a term paper telling you what presentments we returned over the course of from 17 something to 1909 or whatever it was.
Let me read this language again, and I want you to tell us what you make of it. They have been a great force in bringing about many substantial improvements in public affairs.
Right.
What does that tell us?
Tells you that presentments in that world of 150 years ago and more did what you just said. But when you move forward, you're seeing most of those presentments had to do with, railroads and safety and general problems.
There is a history in New Jersey and relatively recent history of presentments dealing with private entities. I mean, one that did not come to this court was the one that we discussed earlier, the 1996 pipeline explosion in Edison.
Oh, I'd like to spend a little time on that if you'd like me to.
Yeah, if you would address it,
Okay,
please.
that's, thank you. First of all, that I don't consider precedential at all.
Understood.
Okay, it's just it's a presentment. Nobody challenged it. There's no appellate.
But nothing came out of it in terms of legal proceedings. But let's talk about it.
Okay, let's talk about it. Let's talk about it. and see what happened. So how did that start? It started as a criminal investigation into Texas Eastern and its employees. All right, criminal investigation, looking to see if there was any indictable activity. That's what happened. And they called witnesses and whatever. And what resulted in that pipeline case was Texas Eastern was found not to be responsible. In fact, they not only said it was not responsible, it did not disregard the risk that the pipeline would fail. So it exonerated them not only from criminal conduct, but it exonerated them from, being named in a presentment because they did nothing wrong. And
why is that significant?
well, I don't think the pipeline case is significant at all.
But I mean,
Why-
why is it significant to your argument that this started out as a criminal investigation of the company and its employees and evolved, certainly the information we have anyway is sketchy about it, but evolved into a presentment?
Well, involved in a presentment because of the recommendation by the grand jury that federal laws be amended, that state laws be amended to make sure that pipeline remained safe.
But here
Doesn't that
again, we have-
underscore, I'm sorry.
Go ahead.
Doesn't that underscore the conversation I had with Mr. Zuckerman with regard to the fact that we can't predict what will happen with a grand jury investigation and where a grand jury investigation will lead or what the result will be?
Well, as I said in my opening, if anyone has any, I didn't say it like this, but if anybody has any question where this is going, when they say way back in 2019 that they're going to replicate what happened in the Pennsylvania grand jury, and I don't know whether any of you have read that.
I understand that the Attorney General made those statements in the press release, but what occurs with a presentment if the grand jury decides to issue a presentment is within the grand jury's authority. You agree?
But first of all, it's not just the then Attorney General in 2019 that was saying it. They continue to say it to the
I
president.
understand what the Attorney General's office has argued and has said. It would be the grand jury that would issue a presentment if one is issued, correct? The grand jury is the one that conducts the investigation.
The grand jury would conduct an investigation, yes. Well,
And my question was, your recitation of what occurred in the pipeline case underscores the argument that you can't speculate as to what will happen with a grand jury, whether a grand jury in a criminal case will indict, or whether a grand jury in a situation like this case will issue a presentment, and what that presentment, the substance of that presentment will be.
there are grand juries that sit 5 days a week, 50 weeks a year presently. If there is any evidence of criminal conduct, they don't need a special grand jury to indict that conduct. They
Well,
all along.
Let me ask you just very generally, we do not know what a grand jury would do with this case.
Well,
We don't know if a presentment would be issued, and we don't have any idea if one was issued, what that would say. Am I right about that?
Most
because you're-
respectfully, it
So we can
may
sit
be,
here,
it may be written already for all I know.
but there's no
it's-
grand jury impaneled.
Pardon me?
There's no grand jury.
There's no special grand jury for this case. They're coming,
Jury
they're
has not
coming
begun.
into, it's different from the typical situation. They're coming into this with the notion that a grand jury should issue a presentment against the Catholic Church, its priests and its bishops. That's what they're going into this with. And, you'd have to be Rip Van Winkle to not realize what is going to come out of this. I can tell you what's going to come out of it. They're going to say that from 1940 to the present, because that's what the subpoena included, that there was problems in the Catholic Church with child sexual abuse in the movement of priests. They're going to say that. I could write it for them, but it's not imminent.
And you're
It's
saying,
historical, and that's what Judge Warshaw said. It's not the, it's
But
not,
right now, we don't know what it would say if there was even such a document. Am I right about that? We
of
do
course
not
you don't know, you don't know exactly
predict-
what they're
you
gonna
can
say. Of
predict-
Does
course.
the trial court even acknowledge that it, quote, does not know ultimately how the attorney general intends to proceed?
Well, I think the rest of his opinion sort of belied that. I think he may have, I'm not saying he didn't say, he said that, but the rest of his 75 pages said something different. He knew exactly what the presentment would say. If he didn't know or think what it would say, he wouldn't have taken the action he took and found that it was not hypothetical and that he could take the action to cut off the presentment at that point.
Why isn't the assignment judge's review sufficient at a later point once a presentment exists, if it ever did?
Because the subject matter of the presentment is improper. I mean, just look at your own rule. I mean, the word public is mentioned, I think, 10 times. And it talks about all public affairs and conditions, but it talks about censoring a public official, when that public officials association, et cetera, for subparagraph A. B, it talks about if the public official is censored, the proofs must be conclusive. And I forgot which justice pointed that out, that the existence of the condemned matter is inextricably related to non-criminal failure to discharge that public officials' public duty.
Your comment was subject matter is inappropriate. The subject matter is longstanding sexual abuse. Why is that subject matter inappropriate? And allow the assignment judge to make the determination if any of the individuals that were discussed or that were identified, if that is something that may be stricken at a later point, why wouldn't that be the proper remedy?
Because it's not the sound administration of government. If you read, when you read again, Camden 1 and Camden 2, it's the sound administration of government. And even in Monmouth, they were talking about the fact that the police officers and the municipalities did not take action to take those pornographic magazines off the newsstand.
What if the presentment in this case said much the same, spoke to resources that law enforcement have, spoke to the adequacy of law enforcement's response? Would that be an appropriate presentment?
You know, we first heard that adequacy of the law enforcement's response in their appellate brief. It was never argued below.
So I would suggest we put that aside for the reasons that Justice Pierre-Louis questioned about. We don't know where this grand jury will end as its investigation evolves.
Well,
So assume that becomes part of it.
I didn't hear your last part.
Wasn't in the press release, but assume it becomes part of the grand jury investigation. Would that then be an appropriate presentment?
No, it's not an appropriate presentment. And think of this. Included in my appendix in the appellate court was articles galore of other religions, the Muslim, the Orthodox Jews, the Baptists, the Episcopalians, on and on, who were talked about as having worse historical problems and more current problems than the Catholic Church. Is this court going to permit the next case to be the Methodists? It's a slippery slope. That's why you have to cut it off somewhere. You cannot do it where you're naming private individuals or private entities. Just as Justice Hoffman said, you can't take TikTok alone. Maybe you can do a presentment against talking about social media and its effect on children, but you can't pinpoint.
Well, if you can do a social media presentment that's generic and deals with all the different companies or some subset or categories, that would be inconsistent, I think, with what you are saying, which is private entities are off limits. So where's the line drawn?
I believe that private entities and private individuals are off limits. When you start with
So if
Chief
TikTok
Justice,
or, you know,
if you
there's
start with
presentment-
Chief, I'm sorry.
No, Facebook, TikTok, whatever it may be, they change daily as far as I can tell. If there's a presentment against them as a group or categories, that's off the table. Because I think you just said might be okay.
Well, it's not before me now, and I haven't even thought about that. I only thought about it when Justice Hoffman brought up a specific company, and that would be specific individuals in that specific company. And so that's what made me think of it. But when you go back to the rule,
Is your argument that one specific religion was being targeted? Is that brought under the free exercise clause or the establishment clause? Or is it an argument that, as you just phrased it, seems like it would equally apply to TikTok versus Facebook versus some other social media company?
well, we didn't reach the establishment clause issue in the trial court.
But you never made
and
it.
not in the appellate court either. So we didn't brief it, except for maybe a couple pages in our trial court brief. But since the trial court never dealt with it, he said that he didn't have to deal with the First Amendment issues. He could
Did you
decide.
ever brief anything about
I'm
the
sorry?
Did you ever brief anything before any court about the free exercise clause?
We briefed it in the trial court.
I thought
But-
that was only an establishment clause claim, and I'm specifically asking about the free exercise clause.
I apologize. I didn't prepare for arguing the First Amendment because it's not before this court right now. So I don't want to speak ignorantly and unintelligently about it. So I apologize, Justice.
Is there any evidence in this record that the presentment would address imminent matters?
Is there anything in this record that it would impact imminent matters? I'm sorry. A Monmouth requires that it be imminent. There's nothing that the Attorney General has proffered at all to demonstrate that there's anything imminent, just the opposite. I mean, the statutes of limitation for criminal prosecution in New Jersey was eradicated in 1996.
But even Justice
So-
Bashali's question, when he's asking about anything in this record, what is in this record?
What is in this record?
Correct. Aside from, the original press release and there's legal briefing, what is in the record?
What else would there be? I mean, it's their intention that started with press releases, not just one press release. It wasn't a mistake. And they went on throughout their briefing to say that their intention is for the grand jury to issue a presentment against the Catholic Church, its priests, and its bishops.
So it's just to make sure we're on the same page. It's press releases and then legal briefing. There's nothing else in the record.
I don't know what else could be in the record. There's nothing in the record. It's
I mean,
the
in
absence,
general,
it's the
because-
absence of what's in the record that should make you be concerned. There's nothing in the record which indicates that it's appropriate for a presentment to attack and criticize the Catholic Church and its priests and bishops.
But here
When-
again, we don't know what it would do. I know
Well,
you.
No,
I
you
know
do know, but here's what you do. If we start with Chief Justice Grumir in 1907 and go on through Camden 1,
You just
all they
promoted
talk
him.
about is,
No, but I understand that he was talking about it, but there are certainly instances in which a prosecuting authority gets out with a press release and the grand jury does something unexpected.
well, normally, let me answer.
I get normally, but we're talking about the facts versus projection of what might or might not be in a presentment.
Okay, so what you would, or they would propose is what they said. They would have to interview 1,000 or more grand jurors individually, because almost a third of the people in Atlantic City, people in New Jersey are Catholic. And they'd have to, at first they said they'd have to get 5 or 6 grand juries when they argued it in front of Judge Warsaw.
No,
Now
I
they limited it to
understand.
one.
It's a commitment of resources, but my question to you is, how can anyone on either side of this make ask this court to make a ruling in the absence of the document that has existed in every single one of these cases, as far as I know, maybe tell me if I'm wrong about that, which is dealing with an actual presentment?
Because the presentment in all the other cases comes about, or the idea of a presentment or the intention to have the grand jury issue a presentment comes about afterwards. Here, we know ahead of time what the intention is. So you need to rule based on the intention. You don't need to see that Bishop A in 1987 moved a priest to parish B. You don't need to see that. That's not the issue. The issue is more general.
Counsel, if the grand, I'm sorry. Good morning. If the grand jury, if the AG had come out and said, we want a grand jury to investigate the efficacy of the O2 MOU and the 2018 task force. That's what we want them to. And in so doing, they had issued subpoenas.
So doing what?
In so doing, and looking at the efficacy of the O2 MOU and the 18 task force, and in so doing, they had issued subpoenas to the Catholic Church in an effort to try and understand whether the O2 MOU was working and the 2018 task force was functional. I'm assuming we wouldn't be here. I'm assuming you wouldn't be here contesting that. Am I wrong?
Yeah.
I am wrong.
Yeah. Yeah. Because nothing prevented them. They're the ones who were the architects of the 2002 MOU. The county prosecutors and the Catholic Church joined in. Everybody cooperated in 2002. The wording of the 2002 MOU says that the state should revisit it in 5 years or as the need arises. That's what it says in there. They never did. They never revisited it until they decided weeks after the Pennsylvania grand jury report that, we can't be left behind. We have to keep up with Pennsylvania. The problem is Pennsylvania's got a different law, but we got to keep up with them. And we need to have a grand jury presentment that focuses on the Catholic Church.
But my hypo was not about, my hypo was about focusing on the O2 MOU and the 2018 task force.
Okay, so the
If
2002.
if they were very clear when they said, we are going to focus on those two things and whether they have been effective or successful or could be improved, would you be contesting a subpoena that came to the Catholic Church that was intended to look at whether purely those governmental actions were effective, or successful or not?
Yeah, I would be contesting it because I would say that we don't need a grand jury of 23 people from all over the state that have no idea what is really going on. When you have the Attorney General that was part and parcel of the creation of the 2002 Memorandum of Understanding, who is in the best position to determine whether it is working or not working. And they never did. And the reason, as I said in my opening, they never did because it is working. We've had no problems. We haven't had, sorry.
Please finish your
No,
answer.
go ahead. We haven't had any problems since before 2002. And the 2000 Memorandum of Understanding came about because of the Boston Globe spotlight, which put a spotlight on clergy sexual abuse of children. That's when that came about. But we had eradicated the problem prior to 2002, but the Attorney General at that time thought it was appropriate, and we had no objection because we were cooperating throughout. Even before that, we were providing any allegations of child sexual abuse to the local prosecutors, and there wasn't any prosecutions.
Would we be here if the state had simply begun to summon witnesses, victims, to testify in front of the grand jury? Nothing more.
Would I be objecting?
Yeah.
They can summon people before a grand jury anytime they want. It's the result that I'm having a difficulty with. I mean, if they're summoning witnesses for the purpose of identifying criminal conduct of any priest or any bishop or the like, go ahead. We don't want offending priests in our diocese. We've never wanted them in there. And if there is a action that they need to take to bring witnesses before a grand jury for the purpose of indictment, go ahead. That's what Judge Warshaw said, and we agree with.
Does the state have an obligation to announce at the outset that it intends to pursue a presentment at the end? Would we be here if all they had done was summon victims to testify within their mind the idea of a presentment?
Yeah, we wouldn't, what had happened? We would have waited 2 years, 3 years, until all the people who were offended, and we have great sympathy for them, I'm not suggesting otherwise, but all the people in the 70s and 80s and maybe some of the 90s who were the victims, when they are called to testify, no problem. As long as we don't know, and unfortunately, I guess for them, we do know, but we don't know that the result is going to be, or the intention is for the grand jury to issue a presentment. In the real world, and I know many of you have been prosecutors previously, as I have, in the real world, grand jurors are led by the prosecution. And what would happen here, as Judge Warshaw even said, that the Attorney General would write the presentment and you get 23 people or 12 or 13, whichever number votes for it or decides to show up, to raise their hand and say, yeah, go forward with the presentment. They are the ones, to answer your question, in the best position to determine whether the MOU is working or the task force has done a good job. I mean, the task force supposedly had 550 calls. We have no idea. They didn't say that they're all Catholics. Again, there could be calls with regard to Jews and Muslims and Episcopalians and Methodists and et cetera, or the Kiwanis Club for all we know. But they've had calls. But what was the result of those 550 calls? The result was there was one indictment and the fellow pled guilty for sexual abuse in the 1990s, and the other priest was acquitted. Now that should tell you something, that there is no present problem, there's no imminent problem in the Camden Diocese.
That's
So
why, that's why I asked the question, whether there was anything at all in this record that would show that a presentment would address imminent matters. You just referred to 550 calls.
That's what they say, 550 calls, but they don't say anything more about those calls. We have no idea, but we can move to the result of those calls, which is there's been no indictments, there's been no charges for anything other than what I've just said, a priest in the 1990s, and the other one was acquitted. So call the 550 people and see whether there's indictable activity. We don't object to that. It's the fact that a presentment cannot be returned, we believe, against private individuals and private entities. It is a slippery slope that you don't want to go down.
I want to go back to Camden 1 for a minute, Council. In Camden 1, in discussing the opportunity for individuals named in presentments to respond or have an opportunity to answer, the court says the following: the chief objection to grand jury presentments of public affairs urged on us is that a public official or even a private citizen who is in some way associated with public affairs may have charges preferred against him, which he may not be afforded an opportunity to answer. And then later in the same paragraph, the court again states the dangers of a public official or a private citizen from unfounded presentments are far less than those attending other forms of public investigations. Why would Chief Justice Vanderbilt, in this opinion, note private citizens at the same time as he discussed public officials in this manner if presentments are limited to only public officials?
Right. So You basically answered my question. I'm answering your
Did I?
question based on your question, because you said
Tell me.
in there the magic words, and I apologize for not including that. There is a mention of private citizens, private individuals, but what does it say? It says private individuals who are involved somewhat in public affairs, okay? So you can have somebody, the chief of police is being criticized, and his, somebody in his household is encouraging him to violate the law or whatever. I mean, the fact is that the only time you can have a private individual is when they're connected with public affairs. That's what Camden
So
says.
there in Camden 1, there's a private person named in that presentment. We discussed that earlier with opposing counsel, correct?
There's a private person named. So, but it's clear what they say is that if that person has to have been involved to some degree in public affairs. That's what it says. That's what Camden says.
He's the person who hung around the jail.
Right.
No,
So by
Reasons we don't know.
Right. It seems by virtue of
we don't have a presentment. That's the problem. If you rule anything in this case, I
we
would
don't have a
ask that.
presentment here either.
Pardon me?
You just said we don't have the presentments in Camden 1. We don't have one here either.
Well, okay.
We did, there
But
was a
you-
presentment in Camden.
We don't have the text of the presentment.
No,
in
you don't have the
Camden 1.
text of the
So we
presentment.
can't,
No.
we
but-
really can't substantively have a discussion with regard to the particulars of this private person who was named and his involvement with public affairs or conditions. But that
Certainly
that
wasn't-
takes us back to, in this case, we have no presentment. So again, are we prematurely making a determination here as well?
I don't believe so. I believe that the thrust of Camden 1 is all about the administration of government.
Right.
That's what they emphasize throughout.
But we can't
And-
get around the fact that a private citizen was named, someone who does not appear to be a
we don't-
government official, who, I know your hypothetical included someone who was a family member of a public official.
That's maybe a bad, I couldn't think of a hypothetical.
But we have no reason, based on this opinion, to believe that this individual was a government employee, was a government official at all. Yet he's named in this presentment, and there's nothing in Camden 1 that indicates that was improper. And the quotes that I just read from Camden 1 also don't indicate that there was anything improper generally about private citizens who are some way associated with public affairs.
No, there's.
Again, in Monmouth,
In Monmouth. it
in
says that.
Monmouth, the issue was obscene materials being distributed and sold by private entities.
Right.
And the obscene materials and the availability of obscene materials, correct me if I'm wrong, was viewed as a public affair and condition that was impacting the county.
It was a public condition available to all. It wasn't targeting.
Made
One-
available by public entities, correct?
I'm sorry.
Made available by private entities, correct?
Yeah, but yes, it was made available by a private entity, but available to the public. And they didn't name.
This argument
private
before that
entities.
it had to be made available to everyone.
Sorry, say that again.
You made the same argument before that it had to be available to everyone. That in Monmouth, the material had to be available to every member of the public. And I think in regard to the 1996 presentment, you made a similar argument in your briefing that it was only because every member of the public could be harmed. Where does that come from? Because I don't see anything in any of the case law or the prior presentment or Rule 3:6-9 that says that you can only investigate a matter if every single member of the public in the state is impacted by it.
Well, it talks about public affairs or conditions. That means available to the public, not just the fact that it's the Catholic Church and its priests. It's a subset, that's a subset of the population.
So
And we
any,
get all kinds of subsets of populations. That's why I say it's such a slippery slope here, is because where do you end this? Does the local Rotary Club, because it doesn't admit women or doesn't admit minorities, let's say, are they the subject, proper subject of a presentment? And then not only naming the organization, but its leaders. Is that appropriate? I
So
hope
there
you'd
you're
say
trying
no.
to make a distinction by saying that the Rotary Club is it based on number of people that could be impacted? Is it based on reach across the state in which those people live? I'm trying to understand because I don't see a distinction anywhere in the case law that says every single member of the public must be potentially impacted, especially for the examples that the Chief Justice discussed that had been discussed in Camden 1 about funding for private hospital ambulatory services, private tax evasion, domestic violence, dance halls, theaters. There doesn't seem to be any suggestion that unless every member of the public has been to this dance hall, it cannot be the subject of a presentment. So I'm just trying to understand what is the content of the argument you're making? Where does it come from, if not from the case law or the rule?
Well, it comes primarily from the fact of Camden 1 and its holding, we believe, stands for the proposition that a presentment is limited to the administration, being critical of the administration of government. And Rule 369 follows along from Camden 1, Monmouth, and Camden 2, and gets amended. And if you look at the end of your rule, it says in paragraph D, says the assignment judge shall instruct the clerk of the grand jury to send copies thereof to such public bodies or officials as may be concerned with the criticism and recommendations made therein. That goes along with the rest of the rule, which limits presentments to public officials. There be no reason, as the commentators have said pretty much all along, Mr. Q from, I think, Columbia, who was quoted in Monmouth, is very clear in saying that presentments do not include private individuals or private entities. And if you read through these thick law review articles, I couldn't find one that said that private individuals or private entities were appropriate for presentments.
Counsel, I know we've had you up there for a long time and we need to move on. I want to ask one more thing before. The Attorney General has represented to us that they have extended, they've said that they're going to afford the protections of Section C to anyone named who is not a public official. Is there any dispute about that? And do you have anything you'd like to say on that subject?
They are right. They've offered that. And what I believe that is the Attorney General offering to amend your rule, which has existed for more than a half a century in the way that it exists. It stands for the proposition that you can't return a presentment against a private individual or else it wouldn't be written this way. So yes, we have not accepted that offer because we don't believe that it's appropriate, because it's not the grand jury's the grand jury should not be writing or the Attorney General writing it for them, a presentment critical of private entities or private officials. And they're only talking about people there. They're not talking about entities. So they still would be directing the presentment towards the Catholic Church. They didn't say in there that we would agree to redact names and we would agree to redact the church. That might be something that is acceptable, but they still have the Catholic Church in there. So names are just part of the problem here.
We understand your position. Anything you'd like to add?
No.
Thank you. Mr. Giancola.
May it please the court. I'd like to start actually with answering the Chief Justice's question about whether the court's precedent or the court's rules govern. And I think the answer really should be whichever one came last, because the court prepares its rules and issues its rules with the full knowledge of its precedents. And that's particularly the case when it comes to Rule 3:6-9. As the court's aware, Camden 1 was decided in 1952. In 1953, Rule 3:3-9, the predecessor of this rule, was enacted. 1961, Camden 2 was decided. And later that year, the amendment to Rule 3:3-9 for the first time, included the language, public affairs or conditions.
What do you make of the language in Monmouth that speaks to this question? It says, and I'm going to paraphrase the beginning, since the decision in Camden 1, Rule 339, the predecessor rule, quote, has been enacted to further clarify the procedures, but not to limit the broad scope of the Camden pronouncement. What does that tell us about the preeminence of a court rule over a Supreme Court decision?
Your Honor, I don't think that there's really an issue of preeminence here because I think they're consistent in this case.
So you just said the court rule has preeminence.
Well, if there is a conflict, I think that it is the latter that governs. But in this instance, I really don't think that there is one.
Let me just make sure I understand. Which governs if there's a conflict?
The rule, whichever one comes last, Your Honor.
So in this case, it would be a court rule.
Correct, Your Honor.
Overriding a Supreme Court decision.
I think they are both pronouncements of this court.
Is there any law that supports the position you're advancing?
I am not aware of any, Your Honor, but again, they are both pronouncements of this court with the benefit of its prior record.
Do we infer from your question that you think there is a conflict? I mean, from your answer?
I don't think that there is a conflict, Your Honor. I believe that the rule is written exactly the way this court intended, and I think the issue really is a straightforward one here. It's an interpretive issue of what does the word public mean? Public, Rule 3:6-9 is not a particularly long rule, but the word public is used as an adjective more than a dozen times.
Is there a difference between public affairs and public conditions?
There is, Your Honor. Public affairs, as I understand it, and again, this is just dictionary definitions, but affairs typically deals with events, whereas conditions deals with states of being. And so public affairs in our position is that public affairs is dealing with the acts of governance. Public conditions, you could argue, is broader in that, but it's again.
So if children are not getting enough nutrition in some parts of the state, that's a public condition, but not a public affair, probably.
That's a condition. I think there's a question about whether it's public, Your Honor.
Let's say children who are enrolled in public school, or many of them are not getting appropriate nutrition in their lunches. That's a public condition?
Certainly, when you're dealing with the public schools, I think that's unquestionably a public condition.
So a public condition, as you define it, would be a condition of members of the public, not all, some, that is the responsibility of government for having caused it or not dealt with it in some way?
There needs to be a significant component that ties the government to that condition.
But you would not read public condition to mean a problem that exists among some members of the public that should be addressed.
I think if the court wanted public conditions to take on that meaning, then a different word ought to have been used in the rule. Public in that rule is used to modify duty, it's used to modify official, and it's used to modify affairs or conditions. Now, there's no debate amongst any of the parties or anyone who's argued before the court what a public official is. And I think that's pretty well accepted. A public official is a governmental official. And in the rule, public duty is used to define is used to describe duties of public officials. And I think, again, there's no real confusion or debate as to what a public duty is. It is a duty of a governmental official or a governmental body. And I think it would be, well, inartful at least, if the court used public, the same exact adjective, and again, this relatively short rule, to mean something entirely different when it's describing affairs or conditions. There's also, I believe, an issue if the court were not inclined to go with the public equals governmental definition of what is public. Because the state seems to suggest that it should be something that's widespread, but doesn't provide the court with any meaningful standard or rubric to decide whether something is sufficiently widespread to rise to the level of being public as the state would define it.
Doesn't the some of the text of the rule at least cut against your interpretation? I'm looking at the sentence where it talks about as an aid in examining the presentment, the assignment judge may call for and examine the minutes and records of the grand jury, ... to determine if a substantial foundation exists for the public report. So there? Isn't public being used in a way that means not private?
Oh, no, this is very much a public in the sense of governmental. This is, I mean, a presentment is a report of the state. It gets the imprimatur of the state. This is very much a public, i.e. governmental report that is being presented. That's what a presentment is. So no, I think that definition of public being being a governmental function is entirely consistent with also the use of the word public report in the rule. There's been a lot of questions about whether this issue is premature. And I don't think it is here. And I think even the state has acknowledged that for the broad proposition of whether this is the proper subject of a presentment, the court could get to that decision about whether public affairs or conditions means only governmental affairs or conditions. There's a bright line rule. The court.
Are you saying the court should get to this decision
I'm saying
in the absence of a presentment?
I'm saying the court can.
Do you have a position on behalf of Mikas as to whether it should?
I think it should, Your Honor, simply because there's no real confusion here. In another case, if there hadn't been as long and as public a pronouncement of exactly what the state was trying to do, that would be a closer call.
And you're not concerned at all about the fact that every single case that we are all aware of, and tell me if there's anything you're aware of, where a presentment has been evaluated, has been in a situation where there's a concrete presentment issued by the grand jury, reviewed by the assignment judge before the court?
I'm not in this case, Your Honor, because the court has this inherent power to regulate its own house. It has sweeping authority, it's described, to govern that, and that includes, and its house is the entire judiciary, which includes the grand jury. So I think it is entirely appropriate for the court here and now to pronounce that governmental, that public affairs or conditions requires there to be a governmental nexus. It would certainly save a lot of time and resources, and similar to a summary judgment motion or a motion to dismiss, the court has the ability to short circuit things before, instead of letting it go all the way to its conclusion when it's an easy and obvious answer. The state has made it clear in this case that it wants to follow Pennsylvania, and the Catholic League had served as an amicus in 7 or 8 years ago at this point when Pennsylvania's grand jury report was prepared. And as we explained in our brief, there are significant differences between the Grand Jury Act in Pennsylvania and Rule 3:6-9 here in New Jersey.
Do those differences matter if what we're attempting to do is understand and interpret New Jersey's precedent and New Jersey's rules?
It does, in the context of the state has said they want to do what New Jersey or what Pennsylvania did. They made it very clear from their press release and in their briefings that this is what they're trying to do. And they don't have the authority. They don't have the same authority in New Jersey that the Pennsylvania Attorney General had when it prepared its investigating grand jury report.
Boils down to whether there's authority under New Jersey's rules,
correct,
not Pennsylvania's.
Correct. And our point is simply that New Jersey doesn't have the same rule. We should be looking only at New Jersey's rule. We shouldn't be looking to what your neighbor says in terms of whether it was possible to do this in Pennsylvania. That's really.
I don't think that's in front of the court. We're not opining on whether Pennsylvania permits or doesn't permit. It's a question of New Jersey.
Understood, Your Honor.
Either way, if we're looking to the text of the New Jersey rule, how do we get around the fact that it's framed as review of an assignment judge happening after the presentment is presented to the assignment judge and before it is published?
Certainly, that is the rule. But Bergen County, this court noted that it is the first obligation to determine whether a matter is appropriate for a presentment. And that's, I think,
after the presentment has been presented to the assignment judge by the grand jury and before it is published, correct?
That has traditionally been how it's been presented to the court. I think it's already been acknowledged that there hasn't been a case where a challenge to a presentment has been brought before the presentment was issued.
But not only no case, the entire rule, A through E, is all about the assignment judge, exactly when it is reviewed promptly before the grand jury is discharged. The assignment judge shall examine the presentment. And then there's all this conversation about whether the presentment is then made public. So the entire text of the rule is predicated on the fact that the assignment judge is reviewing this promptly and before the grand jury is discharged.
Without question, Your Honor. I don't, however, think it's inappropriate for this court to say what a presentment can and can't do. Even just as a general matter, this issue has already been briefed extensively and argued extensively. I don't think it's inappropriate for this court to make even just a general pronouncement to clarify its rule, to say this is the stuff of a presentment and this is not the stuff of a presentment.
Anything you'd like to add, counsel?
Yes, Your Honor. There's a real issue in terms of the protections afforded to private individuals and private entities. As we explained in our brief, there is a constitutional right to reputation. The Rule 3:6-9 doesn't provide any protections for private individuals on the rule. And I think that was deliberate, not because it was trying to provide lesser protections to private individuals, but because it was trying to provide more. Because I think it was very clear from the fact that presentments are only designed to address public affairs and conditions relating to public officials, that this was not supposed to cover this sort of presentment or intended presentment, investigating private conduct by private individuals. There isn't any redress under Rule 3:6-9.
What is your response to the Attorney General's argument that the concern at the time was that these presentments would be used as political tools against opposing parties or adversaries, and that's why the Attorney General argues the public official language is so specific with regard to the protections for public officials?
I think a more likely interpretation or explanation for why the rule was drafted the way it was is because it's not as if there was no concern for private reputations in the 1960s. Certainly, that was people had a constitutional right to reputation even back then. That wasn't something new. And so, again, I think it's more likely that this court, in reviewing its precedents, recognized that presentments were really only designed to investigate government and governmental action or governmental conditions. It wasn't designed to cover private persons. And the states offered to sort of stipulate away the problem by saying, well, we would agree to they would agree to allow private individuals to object and move to strike portions, is really them trying to just do an end around against the interpretive issue. This rule doesn't allow for this sort of investigation. So this sort of stipulation or offer of stipulation for a workaround really just is their way of avoiding the problem of this is not the stuff of presentments in New Jersey. The state and victims both have plenty of tools. There's plenty of justice that can be done with regards to sexual abuse. The state set up its hotline. Nobody's objecting to that. The state has the ability to prosecute claims, and there's no statute of limitations when it comes to sexual abuse. Victims are free to pursue civil remedies. But what the state's doing here is really trying to seek a presentment as a substitute for indictments. And really, it should just be encouraged to use the powers, the illicit powers that it already has, rather than trying to expand Rule 3:6-9.
Thank you, counsel. Thank you. Mr. Zuckerman, rebuttal.
Thank you, Your Honor. We've been here a long time this morning. I'll be brief. I just want to circle back to this court's earlier questions about sort of the ways in which I think an opinion to reverse could be written, and I'll try to do a better job of answering the Chief Justice's question about what we think would make sense here, what you could or could or should do in our view. So I think there are basically three ways to write a reversing opinion. I think the first is to say this is all premature and stop there. And I think that is entirely logically coherent because, as you heard from the diocese and its amicus, Nobody knows what the result is here. This is all highly speculative, and there is no case saying that you do this review before you have anything. I think the second path is that you reach all of the issues that they raise about what does Rule 3:6-9 mean, and what are all the subsidiary ways in which a presentment could or could not be flawed, based entirely on hypotheses about what a future presentment would look like. How much will it say about an intertanglement with, failures in the government? How many good recommendations will it have for the future? Will it find things that happened very recently or not? All of those kinds of arguments. And then I think the third path would be to write an opinion that is basically says this is quite premature. We're reversing because the rule contemplates review when a presentment is returned. But in the interest of justice, given our supervisory authority and the fact that it is our court rule, the one issue that is kind of cleanly teed up is their argument that matters involving non-governmental sources are forbidden from being part of a presentment ever. And I think you can say that that's just squarely wrong because of everything in Camden 1 that incorporates the common law. And I'll add to the Chief Justice's note at page 65, it rightly says it must have been that they brought in everything from the common law in the 1947 Constitution. So they were endorsing all of those, the dance halls, the liquor sales, the factory fire, the domestic abuse.
And that third option also has an element of speculation in it, candidly, doesn't it?
It has an element of speculation. It's the least it's the only one where I think I can at least with a straight face say it's not so speculative as to be unadministrable.
Well, it's not the least of your three options in terms of speculation. It's perhaps the second least of three, but it has an element of saying, well, we're kind of thinking this is how it's going to come out. So here we're going to comment on yes or no, right?
I agree. It still has some element of speculation, just less speculation than the will it uncover recent problems? Will it have good recommendations or not good recommendations? Will it, discuss governmental failures as well as.
And if you're three, and I know your adversary has a fourth, but of the three that you are asking us to consider, only the first is consistent with the precedent in the state procedurally in which this exercises in looking at presentments, as Justice Wayne-Raptor was pointing out, go through an assignment judge process prior to publication and prior to the grand jury being dismissed, which then is subject to court review with a presentment in hand. Is that right?
That is right. And it's also consistent with our institutional interest as the government in wanting review to happen in the ordinary course and not in this kind of hypothetical premature posture.
Thank you.
I think if the court has no other questions.
Just one. We've had much discussion about protections for private individuals. Does the Attorney General envision a presentment that names priests and others by name?
I think it's too soon to say that. I think it is something that's certainly thought of. It's a thing that has to go before a grand jury. Ultimately, they are the deciders of what a presentment will or will not say. I just want to note, though, as to that question, there's a lot inside of it, which is why I think it is really, really tricky to talk about it in the abstract. Because as to individual names, there may be individual names who are already charged and convicted of crimes. There may be individual names who are already part of civil adjudication, and there could be differences in how those cases came out. There could be individuals who were noted, who have been identified by the church itself as credibly accused, and then there could be individuals who have never before been kind of publicly identified as involved in this kind of behavior, and that would be a fourth category. So I do think there are, and there may be more categories too. I'm not trying to give you an exhaustive list. I'm just noting that I think there are a lot of questions inside the question of whether or not you would want to say something about specific individuals by name, and of course, ultimately, it is the grand jury's decision whether or not to name individual names.
You've offered the protections of paragraph C, as both sides have discussed, which suggests that you at least contemplated asking the grand jury to identify individuals by name. Read that into it.
No, I think it's fair to read into that that's something that we've contemplated. Absolutely. That is exactly why we're talking about that we understand it as possible. A grand jury would vote to name specific individuals. And if that were true, we think it would be appropriate to extend to them the same protections that apply to, to public officials.
Thank you. And thank you to all counsel for the very helpful arguments and the obvious preparation that went into them.